Hello, hello, hello. It is I, Natasha Robinson. I am, as I said earlier, the creator and curator of Legalese Please. This is a digital platform which is designed to decode, deconstruct, and demystify legal language. If you are here with me and you are watching live, please go to the comments section and let me know that you are viewing so that I can shout you out. We are streaming in that's right, three different places. We are streaming on Facebook, we are streaming on LinkedIn, and we are streaming on YouTube. So please take a moment and share on the platforms. If you know of someone who is interested or is a little afraid or scared about what the SAFE Act says in terms of legislation in Illinois, then invite them over. Tell them, come on this side of the internet, so that you can hear a legal perspective, not the only perspective, but a legal perspective from an actual attorney, which is me. Greetings to you, Natasha Robinson. I am the creator and curator of Legalese Please. Thank you, Glency. I see you. Thank you so much for tuning in from North Carolina. Hello, Vicky. How are you? As you all are coming in, make sure that you like or you share. I am shouting you all out as I promised. Leslie Gates Durr, good to see you. Glency, good to see you as well. Vicky from Evergreen Park, good to see you. I'm glad to see all of you all here. So I am going to go ahead and just give a very brief description and some ground covenants. I won't say ground rules. I will say ground covenants. The first thing, you are here in Legalese Please. Thank you for coming on my side of the internet. This is a place that I have created and curated where I am about the business of legal education, especially breaking down legal language, cases, and policies for the everyday people, everyday person, as well as legal professionals as well. And so as a result, there are a lot of times, as you will see shortly, where different things come to our attention from the news, from social media, from conversation. And sometimes a lie goes further than the truth. Sometimes false information is spread quicker than actual reliable information. And so I have created this platform not to persuade you that you need to believe what I believe, but rather to provide information. So with that, a couple of things. One, let me manage your expectations. There is no way in 60 minutes or less I am going to be able to explain a 750-page document that seeks to engage in reform of the criminal legal system in the state of Illinois. I'm just not going to be able to do it. All right. However, I will be able to provide some synopsis and some explanation so that you are able to consider this information and then make up your own mind. I would rather you make up your mind with reliable information than just on a whim or just on a meme. Okay. The second thing is that after this broadcast, if you still have questions that I do not get to, or you have questions that you would rather ask in an intimate setting, I will be having a Zoom room at the conclusion of this broadcast. And only thing you will need to do is you will need to register, which means you just need to put your name and your information down. And then once you do that, you will get the invitation for the Zoom, and then I will be there on that side of the internet waiting and willing to answer your questions as it relates to this. Okay. The other thing is that in this space, we keep it real and we keep it respectful. I'm here in my home office. I talk to you like I would if you were my friend, if you were my loved one. I do care about you, even though I've never met you. And there may be some times that something will happen that is not predictable. Right now, the chair in which I'm sitting in, it is a habit to act like it has hydraulics. I don't know what that's about. But, some things may happen. There may be a knock on the door, all that type of thing. So all I'm saying is just get comfortable. Get you something to eat, something to drink, and understands that while we're keeping it real and respectful, while I can encourage debate, I respect debate. At the same time, I do not tolerate disrespect. So if there's anybody who is sliding into the my DMs or sliding into the comments with disrespectful language, the ushers will see you out. Okay, the ushers will see you out. Who are the ushers? Don't worry about all that. Just understand that you will be ye dismissed if at any time you bring any type of language or energy that precludes us from learning or at least engaging in a dialogue. All right, so with that, let me say hello to everyone that I see coming in. Good morning, Ivy. How are you doing? Good to see you, TT Blue. Good morning. How you doing, Sora? Dr. Crumpton. Good morning to my sis, Wusa, Simone Gaucher. Good morning, Ariel. How you doing? Good morning, Ange. How you doing? Good morning, cousin. Good to see you. Good morning, Angela Walton. I appreciate you. Good morning, Angie Walton. I said hello, Angie Walton. Now I'm saying hello, Angie Thomas. Good morning. Good morning. Good morning, Dr. Jory Lynn. If you have not already, please make sure to click like and share on your platforms, okay? And good morning, my Sora. How you doing, Brandeis? Good to see all of you all. So we're going to go ahead and we are going to get started, okay? As I said to you all, welcome to Legalese Please. This is a place where we decode, demystify, and deconstruct legal language. Now, if you are new here and you're trying to figure out why the hell is she greeting everybody that comes in, because that is what we do here. Okay, you may not ever have anyone greeting you by name or looking in your virtual face and saying good morning or whatever time it is that you're watching it. But we do that here because before you or anything else, you are a human being and not a human doing. And I see you and I acknowledge you. Okay, so thank you so much for being here. Oh, we had a bishop here. All right. Good morning, Tim. How are you doing? Good morning, Floru. How are you doing? Thank you for being here. Thank you. I appreciate you. Good morning, Doris. How you doing? This is one of my criminal defense attorney friends who will be in the room. And so I know that I have a lot of loved ones who will be present, who will be able to comment and give some analysis about what it is that's happening. So at any point, you can come into the comments with your questions or your comments, and I will get to those questions as soon as I can, because remember I said, I got a lot to get through in a short amount of time. And I am a person who tries to be a good steward of time. So we are going to go ahead and get into it. Even though you may not physically see me, know I am always going to be talking while I engage in this presentation. All right, so this is called News You Can Use. If you can hear me, if you can see me, I'm hoping that we do not engage in ableist actions and that you are able to have access to closed caption. I wish that I had a different language component for this so that I could habla en español, but I cannot. That I can speak in American Sign Language and all of the languages that convey communication. However, we're working on that. We're working on that. So right now, just know that you are here. And if you can hear me or see me and read the words that are coming across the screen, relax your shoulders. All right. Take a moment and relax your shoulders, because we're going to be getting into a lot of information in a short amount of time. And I want to emphasize the ease in Legalese Please, which is to learn and to do it as best as you can. The content may be uncomfortable, but understand that I want you in a physical space of ease, because studies show that you learn and retain a lot more when you are a lot less stressed. All right, so let's get into it. I'm going to make this a full screen so that you are able to see. And I want to make sure that I see what you see. So if you would give me but one moment, I am able to get this started. All right, so here we go. All right, news you can use. Let me go ahead and take this banner off so that you can see what I see. All right, here we go. If you have not already, please share this information with those that you feel would benefit from it. Now, because I am on full screen, I am not able to see the chat at this time, but I will be able to go back and see your comments. What are we talking about today? We are talking about the Illinois SAFE Act, which stands for Safety, Accountability, Fairness, and Equity Today Act. That is what the SAFE Act stands for. It is an acronym. All right, an overview of today's broadcast. We are going to first understand the terminology, meaning the terms and the words that are used not to just reference this act, but also to be used in the act. So you understand, what does it mean when we're saying this, okay? Because it's important for you to realize that words have power. And I do not want you to just engage in reading something or hearing something and you yourself cannot go and check out what these words mean, which leads me to another point. When it comes to information, particularly law, I strongly encourage you to go to the primary source. The primary source is where the information is rooted and where it is from. So for today's conversation, the primary source is the actual law. Okay. Now, there may be some of you all, I feel in my sanctified imagination, who may be like, I'm not reading that, all them damn 200 and 700 pages. I understand that. So then if you can't get to the primary resource, go to a reliable secondary source, which is me. Okay. So this is what we're going to be talking about today. We're going to be talking about the substance of the act, meaning what is the content? What are the new additions and what are revisions? Because surprise, surprise, some of these actions have already occurred. Some of them are currently occurring. And then there is a balance of those that will start to occur on January 1st of 2023, as well as over the course of the next couple of years. Then we're going to talk about the procedure of the law, the carryout. And I'm going to be just saying the number one thing that can be used as a tool or a weapon. And then we'll get to questions and answers. All right. So a lot to do in a short amount of time. If you have not already, click like and share on your platform so we can get this word out. All right. First, let's talk about terminology. As I said earlier, words have power. And in law particularly, words mean things. It is not one of them, well, you know what I meant. Well, you feel me? No, I don't feel you. I need to know exactly what the words are and what the words mean. And you do not have to be a legal professional to be knowledgeable about the law. That's one of the other barriers that we try to tear down here. So for some of us that have been talking about Illinois is getting rid of cash bail and cash bond, and you're using the terminology SAFE Act, for that particular section, what you're really talking about is the Pretrial Fairness Act. That's what you're talking about. Okay. Now, if you're talking about the SAFE Act itself, I will be discussing what the act is in totality. And then I will be addressing the smaller subsection, which is the Pretrial Fairness Act. Understand that when you look at law generally, and Illinois law specifically, so I know there are people who may be watching from different states and different countries. This may vary in your jurisdictions. So I am focused primarily on Illinois, since it is Illinois legislation I am talking about. When you see the word may equals discretionary. What that means is that there is an option. You have discretion to decide if you're going to do this or if you're not, but you are not forced. You are not made to do it. Whenever you see the word shall or must, that is mandatory, which means the law is telling you you have to do it. Okay. Now, does that mean that it's always done? Absolutely not. But the law is saying, look, there's no wiggle room here when we use the term shall and must. Whenever you see the letters ILCS, that stands for Illinois Compiled Statute. That is a citation for Illinois state laws. For your states, it may be different. But for Illinois, if you see something, for example, that says 725 ILCS 5/110-5, that think of it like if you're going to, for example, reading the Bible and it says that you're going to go to John 3:16 and you know where to locate it. It's the same thing for Illinois. You can go to this statute and look it up, and it will let you know what the law says. Whenever you are reading now the words and the term pretrial release, that is the term that has replaced bail or bond in the statute. All right. So instead of talking about bail or bond, seeing that word, the new term that will be used from here on out is pretrial release. Now, bail or bond is nothing more than the amount of money attached to a criminal case that guarantees a defendant's appearance in court. According to the Illinois Criminal Justice Information Authority, bail is the conditions of release and bond is the court order agreement for release. Now, in Illinois and a lot of other jurisdictions, bail and bond are interchangeable. So I don't want you to get hung up on those particular terms, but I do want you to know that there is a difference. In Illinois, before January 1st, 2023, there were 3 ways that you could have a bond. You could be released on your own recognizance or your identity, which is an I bond. You could be released on a D bond, which means you post 10% of that bond amount. So if your bond is $10,000 D, you would need $1,000 to get out. If your bond was $500,000 D, you would need $50,000 to get out, so on and so forth. And then you had no bond. No bond is when your bail or your bond was withheld because there were factors in the law that stated you needed to remain in custody. One thing that I want us to know is that when we're talking about bond, what we're talking about is the fact that bond and bail is to guarantee your appearance in court. It is not to serve as a punitive measure. It is not to serve as a type of where this is going to be a gotcha, where because we have all of the information, we have the witnesses, we have the video, we have whatever, that you are going to be punished through your bail or your bond. I'm not saying that that does not happen, but what I'm saying is the bail and the bond is set to guarantee your appearance in court. And there are certain factors that the judge takes into consideration when setting a bond. Now, I also hear some of y'all say, well, what's the big difference if you have someone who's photographed, you have 7 witnesses, you got fingerprints, you got blood, you got whatever? Well, to that, I say that there is a difference between factual guilt and legal guilt. It is in our country that defendants, suspects, those who were charged with crimes, are considered presumed legally to be innocent. Now, while they may be factually guilty in court, they are considered to be presumed innocent. And until there is a finding of guilty by a judge or jury, or there is a plea of guilty, each and every person who is arrested and charged in the United States and its surrounding jurisdictions are considered and presumed to be innocent. Okay? I didn't write it. That's what the people did. Okay? So I want you to know about that. Okay? So let's move on. What is the S.A.F.E Act and what does it address? Well, when we are talking about the criminal legal system in the United States, there are 3 components. The first is law enforcement, and that is relating to anyone who serves as a peace officer or a police officer, okay, federal or state. Particularly for now, we're going to be talking about the state level, okay? I see you, Emmanuel. How you doing? All right, so the components are, hey, Shay, another student. I have my former students in the chat. I just want you to know this is important. If you're coming in, please click like and share on your platforms, okay? All right, so the first component is law enforcement. The second component is courts, all right? Anytime you go to court, whether it is for a misdemeanor or a felony, when you go to court, you were in the second component of the criminal justice system. And then the last component is the correction system. The correction system includes all forms of accountability, whether it is sentencing to incarceration, whether it is being supervised by the state, whether it is conditional discharge, probation, that all falls under the corrections component. Okay, so there are 3 components to the criminal justice system. What does the SAFE-T Act address? It addresses the entire system and all 3 of these components, which work sometimes independently, but most times is interdependent, which means they do not work in a vacuum. Okay. Now, as we're talking about the SAFE-T Act, that is the act, that is the legislation that was signed into effect by Governor Pritzker. The governor only was able to sign it into law after the legislators, those that made the law, they were researching and they were debating and they were reading different data points, interviewing different people in order to come up with this type of law. And please understand, there are parts of this legislation that are bipartisan, which means that it is not just a quote unquote Democratic thing or a left thing. Okay. There are parts of this legislation where you have Republicans, independents, and Democrats that are saying there are some things that need to be changed. And as a result, these are some of the things that need to be changed. Now, let me get out of here so that I can move my picture so that you can see all of this information. All right. So some of the highlights of the SAFE-T Act is community law enforcement and other first responder partnership for deflection and substance abuse. This is a new section of the SAFE-T Act that says that law enforcement, which was already existing, or other first responders, that's the new language, that they can receive training for these following things: for medication assisted treatment, for knowing why drug treatment works or does not work, for avoiding racial bias and deflection, for eliminating stigma for people with substance use disorders and mental health, for promoting racial and gender equity in deflection, for working with community partnerships and deflection in rural communities. That is part of the SAFE-T Act. What else we have? We have funding for deflection programs, which means not everyone has to be arrested, not everyone has to be prosecuted, but there is going to be funding for those communities that have been impacted by the war on drugs, communities that have police and community relations issues, and communities that have a disproportionate lack of access to mental health and drug treatment. That is what is in the SAFE-T Act, not the meme that is circulating around that is trying to incite hysteria. There's a difference between concern and fear and hysteria and misinformation. When you talk about the SAFE-T Act, you're going to be talking about these things. There is now the creation of the Pretrial Practices Data Oversight Board, which is stating that now there is going to be a collection of people that are going to be reviewing how people are being arrested and what is the process of pretrial. So if they miss court, if they do not have the correct information for the risk assessment, which I'll get to in a moment, these are the things that are going to be under this SAFE-T Act. There is going to be a new section, which is they're going to be a working group of people who are going to be looking to see how is it that victims of domestic violence, how they're going to be affected and what can we do to protect their safety. This is not one of those things where you've been hearing in the news or hearing in different conversations that everyone is just going to be up for grabs. No, there is legislation. There are laws to make sure that we seek justice and we seek it in the way of protecting those who have been subjected to domestic violence. And so sometimes in domestic violence courts, There may be order of protection. So this group is going to be looking to see how can we strengthen to make sure that people don't just violate orders of protection. How do we make sure that we are engaging in trauma-informed information so that we're not just looking at a person if they are going through something and say, why are you doing what you're doing? Instead, trauma-informed research is what happened to you and what can we do to be proactive in our treatment to make sure that we do not fail you individually and as a collective. All right. Other things that are in the SAFE-T Act is the Illinois Police Training Act that is going to be increasing the standards for mental health screenings for those who are probationary police officers and permanent police officers. So this is taking away the guilt and the shame of police officers who need or may need counseling sessions and different screenings. Because sometimes there was a lot of vitriol when you had a police officer in no matter what role they were in, they needed help, they needed assistance. And so if you look at the statistics and see the number of police officers who have been committing suicide, you will see why this training and why this assistance and resource is necessary. Another new provision is that for probationary police officers, there's going to be training about crisis intervention training, which means that police officers are going to be trained from the beginning about what do you do when you interact with someone who has a police called on them and they may be a threat to themselves or a threat to the community. And what happens when you are able to discern their criminality, alleged criminality, from their mental issue. So this training act makes sure that we do not criminalize mental health, but rather there are standards and procedures and protocols and classes and training that help officers understand about crisis intervention training. And also, because they are officers to serve and protect, this act also allocates funds and resources to make sure that they remain well, that they make sure that their mental health is optimal. This is what is not on a meme. This is what is in the SAFE-T Act. I already talked about the crisis intervention training, which is now a collaboration. You have villages and cities that are already doing this. I know specifically of Orland Park, who has a crisis intervention training where they do not arrest everyone that has a mental health episode, but rather they bring mental health professionals to the scene and they work with the people and then they try to prevent the criminal legal system from continuing to implode. I know that is not for every village and every city, but that is an example that I know from the top of my head. Okay, another part of the SAFE-T Act is making sure that all law enforcement agencies, what does that mean? All, it means all, okay? All law enforcement agencies in the state of Illinois, they have to use body cameras, okay? Not just for those who may be just as involved, but also for themselves. And so the rollout is for municipalities and counties with populations of 500,000 and less. It's already happening. It already started January 1st. Then for those who have populations of 100,000 or more, your body cameras by police will be implemented by January 1st, 2023. For populations of 50,000 or less, January 1st, 2024. And for 50,000 or less, January 1st, 2025. For the Department of State Police of Illinois, all body cameras shall be in place by January 1st, 2025. So the SAFE-T Act is not just jumping off on January 1st, 2023. It's happening already. And so these are some of the ways in which this legislation seeks to try and make sure that the system, the current system, does not implode. Okay, other notable provisions. A new section is a duty to aid, which is if a police officer, as reasonably practicable as can be, if a person is injured, either because there was a use of force or otherwise, they have to render medical aid and assistance. We've seen around this country where there may be some law enforcement officers, not all, but there are some who have used force or have seen a suspect suffered medical injuries and they have refused to assist them. We're in Illinois. That is not an option. You have to, as a law enforcement person, as reasonably practicable as it can be, you have a duty to aid. You also have a duty to intervene for law officers. What does that mean? That means that if a police officer, a peace officer, sees another sister or brother peace officer using unauthorized or excessive degree of force, they do not have to wait to talk to the sergeant. We call them in Chicago the white shirts. You don't have to wait for the commander. Okay, you have an affirmative duty for peace officers to intervene, which means that they're trying to take down the blue wall, which is where some officers may not report this information for fear of being punished, for fear of being demoted. This is also in the S.A.F.E Act. This is stating that this officer, if you see another officer doing something that is violating your code or violating the law, that you can discuss without punishment, without reprimand, what it is that they're doing. Okay, this is all under the S.A.F.E Act, the Safety, Accountability, Fairness, and Equity Today Act. Another part of the act is talking about victims' rights. The act changes crime victim compensation by expanding the definition of crime victims for compensation purposes. It increases the time period for those who are trying to get compensated by way of restitution. So instead of there being a statute of limitations that said you could only do this in a particular time, this act increases that time period. It allows the Attorney General and the Court of Claims to accept a compensation claim. It expands compensation to sexual assault survivors. Okay. Also, if you have been the victim of any crime, but your criminal history has been used against you previously, this act prohibits you, or rather, it prohibits you being precluded from getting compensation. So your past cannot be used against you if you are the victim of a crime. And then, of course, this also includes increasing support of loss of future earnings, which is in civil law is called compensatory damages and funeral costs. All right. Also, the S.A.F.E Act tells the state's attorney, the prosecutors in the state of Illinois, that you have to notify crime victims of the defendant's initial pretrial hearing and allow them an opportunity to obtain an order of protection. So this is not just tilted toward letting, quote unquote, this so-called purge occur. It is trying to make sure that in one iteration, justice, if it cannot be served, at least it could be on the menu. Okay, trying to make sure that both victims and defendants' rights are protected. Now, again, I told you at the beginning of this broadcast, I'm not trying to persuade you on what to believe. I am simply here to provide information and explanation of what is happening. Now, this is where we have a lot of people who are up in arms, which is the abolition of what's happening? Because I was going to say cash money. Shout out to Juvenile. What I am trying to say is the abolition of cash bail and bond. This is a new section. It is under, remember I told you the very beginning of terminology, 725 ILCS 5/110-1.5. New. That means it's new. It means that on and after January 1st, 2023, posting cash bail and bond is abolished except for an extradition act, a driver's license compact, or a non-residence violator compact, which you're going to have to look that up because I did not. Okay, just understand that the majority of information that you need to know is in this act, but don't take my word for it. Read it for yourself. This is the law that will be unfolding on January 1st, 2023. Okay, now this is also part of the S.A.F.E Act. I want you to think of the S.A.F.E Act as the umbrella, and we are going to go underneath the umbrella to see what specifically is covered. Now, I want you to see at the top where it says S.A.F.E Act Police Provisions, slide 104. That means that there are so many different things that are either being revised or being put in place to make sure that we, the state of Illinois, do not continue to engage in the mishandling, the mistrust, the confusion in police procedures, enforcements, and practices. So the S.A.F.E Act talks about new standards for when police use force. It requires officers to provide aid when necessary after force. If officers want to intervene, if they see their sister or their brother officer using unauthorized or excessive force, they can do that without punishment. Okay, it talks about mandating use of force reporting to the FBI. It requires police to report deaths of police it requires reporting of deaths that are in police custody and due to use of force. Okay, slide 2. What does this act also do? It creates a statewide decertification process for officers. It creates a stricter body camera regulation and a class 3 felony. A class 3 felony is 2 to 5 years in prison for those who wish to engage in willful attempts to obstruct justice. I'm talking about police officers now. Okay, now you can also have an investigation of officers and do it anonymously. If there is any destruction of police misconduct records, that is gone. You cannot do that. Now, I want you to think about the case versus Jason Van Dyke, the former officer who was charged and convicted of killing Laquan McDonald. And there was a phrase, 16 shots in a cover-up. There were brother officers who, when they were going through the investigation, and I'm not lying, look it up for yourself. When they were going through the investigation, some of these officers were whiting out or rewriting or hiding or changing the language in what actually happened in the police reports. Okay, this act stops that. This act stops people who are engaged in not only misconduct, but in illegalities, trying to cover their ass. Okay, I tried not to cuss, but I got all the way to 1039 and I broke my own promise. All right, so what else does the police provisions do? It makes data on misconduct more accessible. It also provides a review panel for law enforcement certification. It enhances automatic and discretionary termination of officers, those ones who some people call the bad apples that make all officers look bad. Okay, if there is verification of training and employment, we want to make sure that the officers who live in our communities, who serve our communities, that they are the best and the brightest. Now, does that always happen? Of course not, because when you're dealing with humans, there is always the ability for humans to mess up, for humans to fail, for things to get past us. But this is what this act, according to the language, this is what we seek to try to avoid. And then lastly, this is just police now. This is just the first component of the criminal legal system, is making sure that crime statistics are reported monthly for people who are in custody. You now have, as of January 1st, 2023, up to 3 phone calls within 3 hours. Do you remember when you were coming up, for some of us, where they said you have the right to a phone call one phone call. That is changing. This act allows you up to 3 phone calls within 3 hours. If there is a need for medical treatment for people in custody, this law says that you can receive that without unreasonable delay. Okay? This is just for the police part. Now, another part that people have been discussing is it requires officers to issue a citation rather than arrest for certain low-level offenses. Do you see the numbers that are in the brackets? When you go to this website that I'm going to show you, it is going to show you the law, the location that actually states what these summarizations are. Okay. And the reason, one of the main reasons why the SAFE-T Act was created in the first damn place is to make sure that persons who live in poor communities and persons who are brown and black, that they do not experience systemic and systematic racism, genderizing, inequality, inequity, punishment through capitalism, trying to prevent someone who cannot post $100 for their bond, that they don't just sit in custody longer than the sentence that they are actually facing. That is why the SAFE-T Act was created. And we'll get more into that in a little bit. Some other things, we're now into the second component, which is the courts, which says that it abolishes cash bail. But what else does it do? It adds notification of pretrial hearing to crime victims. In the event that someone is released and they don't hold up their end of their bargain that they promised, their pretrial release is going to be revoked. Okay, people are not going to be out here just wilding out and chewing through the bars at 12 o'clock on 12 o'clock midnight on January 1st, 2023, just waiting to get out, which is what some of the information that is being circulated would have you believe. There are people who benefit from lack of knowledge, from your fear, from misinformation. And all I am simply saying is read the law. And if you don't want to read the law, ask someone who does, which is why we're here. All right. The third arm of the legal justice system is correctional issues. So now this SAFE-T Act requires reporting of deaths in custody. There are going to be sentencing credits for those who have been in custody and they get, day for day or whatever the calculation is. All right. If there are mandatory supervised release terms, we call that parole. It is under this section. This also clarifies the credit that you receive if you are detained at home. All right. Also increases eligibility for individuals who were sentenced for certain drug offenses to enter diversion, which means you don't go into the court system, or probation programs, which releases you from incarceration. Okay. These are some of the things that have been addressed in this SAFE-T Act. Now, let's go from the SAFE-T Act in general to the Pretrial Fairness Act in specifics. Okay, according to the law, 725 ILCS 5/110-4, all persons in subsection A, all persons charged with offense shall be eligible for pretrial release before conviction. This is where everyone is like, oh my God, had your kids, had your wife. This is going to be all this type of thing. Let me break it down for you in a legal perspective so that you understand. To be detained under the Pretrial Fairness Act, there is a detention of eligible charges. We'll go through that. There is a verified petition from the state's attorney's office, which are the prosecutors, that state that a person, if they are a threat to public safety or there is a willful flight concern, and lastly, an order by the judge for detention, then those are the reasons why someone who may be eligible for release may in fact not be. Okay, so I just want you to hold on to that. Also understand that the Pretrial Fairness Act, again, is not created for who you think it's created for. It is created for those who have been disenfranchised by their race, by their gender in some effects, by their socioeconomic status, where in short, their race makes them a criminal. Their location, where they live, makes them a criminal. What they make or what they don't make makes them a criminal. And when I say a criminal, what I am saying is that now you have persons who are accused of taking bread or accused of holding a little marijuana or something like that. I'm not minimizing the issues. What I'm simply saying is it does not make sense to have someone who is facing a punishment of 30 days in jail to wait in custody for 6 months because they cannot afford to pay bail and bond. That is what this pretrial fairness was created to eliminate. Okay? So I just want you to take this under consideration. Take this under advisement. Okay? It's so easy for us to share misinformation than to share the truth. There are some of us who were satisfied with ignorance. I said it, and before I take it back, I'll add more to it. And I don't mean ignorance in terms of stupidity. I mean ignorance in terms of you giving me information and I refuse to take it for no other reason than don't confuse me with the facts. Let me sit in my fear. Let me perpetrate that fear. Let me share it so that other people can't be scared. Now, this I'll tell you for free. Some of these people and some of these organizations that are engaged in the sharing of this fear are profiting from our fear and our lack of information. I'll say it again. There are some organizations and there are some people who are profiting from our lack of knowledge, our inability to access knowledge, and our willingness, or rather unwillingness, to find out what the truth is. Okay? There are some people who want nothing more to profit because of your demise. It could be physical, it could be literal, it could be figurative, it's whatever. And I'm going to show you that I can tell you what I mean. Okay? So I'm going to stop sharing the screen for a minute so that you are able to see and able to comment, because I know I went through a lot in a short amount of time. So if you have something to say in the comments, please take your time and I will shout you out, answer any questions that you have. Thank you, Ida, so much. It's my pleasure. I see cousin. I see you, cousin. Jennifer Gill. Jennifer, I am going to share your comment so that people will understand how this looks in everyday life. Okay? Kimberly do, yes. Thank you for these teachings so we can know. Yes. JM Stance, my soror. Another thing that people are not acknowledging is that law enforcement officials were part of making this law. Absolutely. But you're not going to hear that. Okay? You're going to hear more of the opposition as opposed to the collaboration. Okay? Jennifer Good, yes, you are welcome. No, thank you. Kish, my soror, yes, thank you so much. I appreciate it. So I am going to see if I can share this screen so that if you don't get anything else, because I still got a little bit more to go. If you don't get anything else, let me show you something really quickly. And it is going to be what I talked about, which is the blurb from my good buddy, Jennifer Gill. I don't know if I can. Yes. Yeah. Hold on a minute. Let me come back. Will this be available? Yes. Yes, it will. It will be available to watch later because it is recorded on Facebook Live, on my personal page, on Legalese Please LLC page, and also on YouTube, as well as LinkedIn. Okay. Yes, you can repost this information. Sora, thank you so much for being here. Ida, which I'm sure you named after Ida B. Wells, I'm presuming. The people must know before they can act, and there is no educator to compare with the press. This is what podcast media should do, educate the people. Salute. My salute to you. Thank you so much. Okay, so now what I'm going to do is I am going to go back to the presentation so that I can continue to show you what else the law is saying. Okay, we only have a few more slides to go. Here is an overview of the Pretrial Fairness Act. Here are the main changes. Number one, it eliminates monetary bail as a release condition. Judges will now decide pretrial release or detention based only on the defendant's charge type. Is it a felony or is it a misdemeanor? And then of those two options, are they a risk of willful flight and are they a danger to a specific person in the community? The other thing is it changes and will impact case flow, volume, time frame, and docket structure. Now, I am not here or in the business of talking about how it affects other entities because I am not in those entities. But what I will say is that the money that is going to be or would have been allocated for bail and bond, I'm going to show you where that money could possibly go. Okay. The other thing is that it regulates use of risk assessment tools. So what happens is that, say, for example, because I know people like examples, I am charged with aggravated UUW, which is aggravated unlawful use of a weapon. What that means is that once I am arrested, then I am brought to court for my pretrial hearing. And the pretrial hearing is the prosecution will read what they believe the evidence will show if I went to trial. The defense attorney, either whom I am appointed to or who I hire, they're going to talk about who I am as a person, what I've done in terms of job, education, if I'm a parent, if I take care of children, aging parents, what have you. And then the judge will say, okay, looking at the person, what the person is charged with. I just said I was charged with the aggravated unlawful use of a weapon. That is a felony. Then the judge is also going to look to see, am I a risk of flight? Am I going to dip off and go trick off somewhere else in another state, another jurisdiction? And am I a danger to a specific person in the community? That is the process of how it will go. And then based upon the answers to those questions and the risk assessment, which is completed and shared with prosecution and defense, then the judge will say, Natasha, yes, Natasha, no. Okay, that is what is going to happen. At least that's what we predict is going to happen. Now, when it gets to pretrial being denied, pretrial is going to be denied for those cases where a person presents a real and present threat to physical safety and which the state has to prove, and where pretrial is denied, then again, the burden of proof is on the state. So what does that mean? There are going to be certain alleged crimes. Remember, I said alleged because the law says no matter how much evidence someone think you has, you are presumed to be innocent. Okay, so I got news for you. For this law that you are looking at right now, for subsection C and D, these are not new laws. These are not new subsections. They have already existed. The only thing that is different in these subsections is the word pretrial, and pretrial replaces the word bail. What is new in this particular section is subsection A. Okay, so now you have the Safety Act, and the subsection or a section of it is the Pretrial Fairness Act. Now, this conversation merits a distinction between persons already convicted, persons already charged and are in custody now, and then persons with new cases beginning on January 1st, 2023. All right, so let's talk about the classifications of crimes. Now, it may be different if you're in a different state or a different country, but here in Illinois, you have two main categories. You have misdemeanors, which are those alleged crimes for which you could be punished for 364 days of jail or less. Less can be conditional discharge, which is still a misdemeanor conviction. You cannot get that expunged off of your record. Or you can get supervision, which in some cases can be expungible. Okay, some examples of misdemeanors: battery, assault, your first DUI, theft, possession of marijuana. Again, alleged activity. These are, if you are arrested with these crimes, these are considered to be misdemeanors, and you are presumed innocent until you plead guilty or you are found guilty. For felonies, excuse me, felonies are the more quote unquote serious offenses for which you can face at least 1 year in prison. In some states, you can face the death penalty, but here in Illinois, there is a moratorium or a stop on that. So you can face at least 1 year in prison. Felonies can include murder, sexual assault, kidnapping, possession of cocaine, human trafficking, attempt murder. These are examples. This list is not exhausted. Now, word on the street, which is why I created this episode in the first place, is that you're just going to have all type of wilding out. On January 1st, 2023, there are going to be people chewing through the steel bars in the jail, in the prisons, because there's going to be this purge, okay? There's going to be all these people that are facing all these different criminal accusations. They are going to be released. They are going to jump on your home. They're going to invade your space and invade your community. So if you're charged with aggravated battery, aggravated DUI, aggravated fleeing, which is really aggravated fleeing and eluding, let's use legal language, burglary, drug-induced homicide, intimidation, kidnapping, robbery, second-degree murder, and threatening the police off a public official, rather, that you're just going to be out here just doing all these type of things because you're going to be eligible for probation now, and you're not going to face the weight of what it is proven that you are doing or that you say you have been doing. These are lies, okay? These are lies. Let me show you. Again, the conditions of detention. Persons are detainable if they pose, quote, a specific, real, and present threat to a person. So you have 4 groups. The first 3 is if they are a risk to public safety. Group 1, non-probationable forcible felonies. What are forcible felonies? I'm glad you asked. I'm going to talk about it. Those charged with sex offenses, weapon offenses, domestic violence, and violation of order of protection. This is not a mass exodus from the jail or the prisons. It's actually the opposite. Group 4 is persons can be detained if they pose a risk for, quote, willful flight from prosecution. Group 4, there is going to be a specific focus on those who are charged with class 3 or higher felonies. What do I mean? So, of course, I looked at the meme and then I looked at the law. So the word on the streets is that there's going to be a purge. Let me tell you about the word in the courts. I created this graph so that this table so that you are able to see all of the options. The first thing I want you to know is just because a person is eligible for probation does not mandatorily and automatically mean that they are going to receive probation. I'm going to say it again. Just because you are eligible for probation does not mean you are automatically going to receive probation. Because what is the one thing that all of these people continue to retain? And that is discretion. Discretion. There is no way that you are going to live in a city, a village, or a country where you're going to have these alleged lawbreakers running roughshod through the streets, just kicking it, just doing whatever. Let's understand that the Purge, the movie, was because the government allowed 12 hours of this to occur. where law could not intervene. Do you really think that that is going to happen in these streets? I almost guarantee, and I don't guarantee really, but what I will say is that it ain't going to happen. Now, when you look at all of these charges that are on this mean, aggravated battery, aggravated DUI, aggravated fleeing and eluding, arson, burglary, drug-induced homicide, are some of these probationable? So if you do an aggravated battery, which by the way is one step short, one element short of attempted murder, understand that the class is class 3, 2, and 1. Class 3 is 2 to 5 years in prison. Class 2 is 3 to 7 years in prison. Class 1 is 4 to 15 years in prison. Is this probationable? If you use a firearm, you bet your bottom dollar it is not. You cannot get probation on aggravated battery if you are accused of using a firearm. Now, if you don't use a firearm, is it probationable? Yes. Can you get probation? Sure. Will you automatically get it? It depends. It depends upon the facts and the circumstances that lead to your arrest and what is revealed either in your plea of guilty or in your finding of guilty. Same thing with aggravated driving under the influence. Okay. If it results in a death, you cannot get probation, period, point blank. If it is your fourth fourth DUI, you cannot get probation. Okay. Do you see how the circulation of misinformation can be rampant and wrong? Okay. You can get aggravated for aggravated DUI. You could possibly get probation again, but that's where discretion comes in. It depends upon the facts and the circumstances that led to your arrest, that led to your finding of guilty or your plea of guilty. Arson, which is on this little meme that says you can get probation. Can you get probation for arson? Absolutely not. No, you cannot. Can you get probation for aggravated fleeing and eluding, burglary, and drug-induced homicide? Technically, yes, you can. However, does it mean it is automatic? Absolutely not. Intimidation, kidnapping, robbery. These are all class 3, class 2, and in some conditions, class 1 felonies for which you can receive anywhere from 2 to 7 years in prison all the way to 4 to 15 years in prison and longer if there are weapons that are used, if the victim is a particular age or in a certain station of life. Are you going to get probation for kidnapping? You could, but again, it depends upon the facts and the circumstances of the case. Probation is eligible as a choice, but it is not automatic. Okay? So whenever I say in here, yes, but, yes, but, yes, but, understand the asterisk stands for discretion. The asterisk stands for the facts and the information that leads to the person's arrest, their plea of guilty, or their finding of guilty. So in short, while you may be eligible for probation, probation is not automatic. Okay? Now, let me get out of here because I don't want to show you that yet. What I do want to show you is some of this information that you can access. Okay, so just give me 5 more minutes, 5 more minutes. Let me get out of here and let me come back here. Here I am. All right, so let me share this screen so I could show you that most of this information is not withheld from you. Most of this information is very public. Okay, it's very public. Let me share my screen and let me just start showing you things so you know. Don't take Natasha's word for it. Look it up yourself. Okay. My dad was big for when I asked him something, he'd be like, sound it out. Well, how do I find it? Look it up. Well, how do you spell it? Sound it out. Okay. I am not him. Okay. I am going to show you some of these things so that you understand that this is public information and you can find it. Okay. Here we go. Here's one right here. The Pretrial Fairness Act. Now, if you are a visual learner, like some of us are, then you are able to go to www.illinoiscourts.gov, and there are entire websites with links that are showing you what happens. So this is an example of a flow chart which says what happens if a person is eligible for pretrial release. Okay, if they're eligible, then you go to the yes. Okay, if they are not eligible, then you go to the no. Let's see, did I read that right? Is the person was okay, so I did that in reverse. So if their pretrial release cannot be denied, then you would go to the no, and then you would follow those prompts. But if their pretrial release may be denied, again, they're held. Okay, so this is a pretrial fairness. I know there was some information that was saying, well, somebody is trespassing, I can't arrest them, I can only give them a citation. Again, that's where discretion comes in. Okay, because if they are a threat, if there is a risk of flight, they in fact can still be detained. Let's see another one. All right, issuing warrants and orders to show cause. This is all public information. This is not hidden anywhere. The problem is that it's not accessible because no one knows it exists. Okay, these are all flow charts that you can see for yourself. Here's another one about pretrial appearance activities. What happens? What rights do the defendants have? What rights do the victims have? All of this you can find for yourself. Here's another one, okay, where if you want to go through the flow chart and says, okay, is the offense traffic, a certain type of misdemeanor, a petty business, or ordinance violation? If the answer is yes, then there are steps for that. If the answer is no, then there are steps for that. Okay, so all this is information. This information you can get from the Illinois Courts Pretrial Implementation Task Force, which was created in 2020 to help prepare the justice system for the changes that are going to take effect in 2023. So while we were pandemicking, there were other people that were planning practices, planning intentions, planning on how to get the information out. But if you don't know the information exists, or if you don't know where to go, then you'll never get it. Then you will be left to be a co-conspirator in your own demise because you will believe the false information that is always readily accessible. Another place where you can go is the Illinois Criminal Justice Information Authority, which is ICJIA.illinois.gov. Most of this information that I share with you today is from this website. It breaks down the summary of the S.A.F.E Act. It talks about who is affected and how. And then if you click on these particular numbers, it takes you to the actual statute citation so that you can read it for your own. Okay? These are all things that you have access to, that you can get. Now, another website, which I recommend that you pay attention to and follow, is prisonpolicy.org. If you want to know about mass incarceration state by state, you just hover over the state of your choosing, and you click on that state, and it will tell you about that state. This is why the S.A.F.E Act was created, because let me tell you about the country and about Illinois. Illinois has an incarceration rate of 497 per 100,000 people, meaning it locks up a higher percentage of its people than almost any democracy on earth. How many Illinois residents are locked up and where? This is the breakdown of that. Here is the Illinois jail and prison incarceration rates. They are at an all-time high, but they're at a high, I should say they are higher because people cannot afford to bail out for low-level offenses. Okay? the number of people who have been detained waiting trial, not being convicted, but waiting trial, that number has risen. And if you look right here, today, Illinois' incarceration rates stand out internationally. This is the United States. This is where the state of Illinois is. Look at other countries: United Kingdom, Portugal, Canada, France, Belgium. The list goes on and on. Illinois is beating a lot of countries when it comes to incarceration. Okay, so things that you need to be aware of. Finally, follow the money of mass incarceration. This is also on the prison policy page. This is the amount of money that is spent to incarcerate people. $80.7 billion in this country, of which 38.4 goes to its employees and 12.3 billion goes to healthcare. Of that money, also $29 billion is allocated for judicial and legal only. We're just talking about criminal law. We haven't even got to civil law. Okay, 5.8 billion goes to prosecution. 4.5 billion goes to indigent defense. That means people who cannot afford to hire an attorney. Policing, this is what I want you to look at. $63.2 billion, not million, $1 billion under criminal law only. That is where money goes. An annual total of $182 billion in this country. Now, why do I bring this up? I bring this up for the simple fact of you understanding, the screen is stuck. Oh, I'm sorry. Okay, hold on. Let me stop sharing. Let me go back because I want to make sure that you see what I see. Okay, let me go back. I apologize. Let me go. Let's see. Let's go right here. Okay, this is what I was on. Following the money of mass incarceration. That is on the prison policy website. Okay, under reports, you got $80.7 billion, $29.0 billion used for judicial and legal. What I got to was policing. $63.2 billion. What does that mean? It means that whenever there is a threat or potential threat of income, those who want to do nothing but profit off of the incarceration of other people, they are definitely going to be engaging in ways that will have you running scared because you are affecting their money. Okay? And for some of us, the incarceration of people is big business, publicly and privately. Okay, so it is 11:15. I've gone over my time by 15 minutes, but this is the time where if you have any questions, feel free to ask them in the chat. If you have not done so already, you can share. You can share this broadcast. There is going to be a time that Legalese Please is going to be teaming up with attorney April Prayer, who is the CEO of Justice Junkie, who is also a dear sister of mine. I call her my sister in the law because she's literally in the law. And we engage in legal education. Okay. Understand that this conversation cannot, as I told you in the beginning, it cannot happen in an hour or 75 minutes. It has to be reoccurring. Okay. And so what I am going to do is I'm going to place in the chat, if you have any questions that you want to ask in the Zoom room, by all means, you can come over there. So LinkedIn, I don't have the ability to put it on your screen. But if you are on Facebook or YouTube and you want to come into the Zoom room, I will be in there for about 30 minutes, 45 minutes to answer questions that you have that you may feel more comfortable asking in a more intimate setting. Okay, so I think that is it for now. Once April Prayer and I decide the dates and the times and the series for which we are going to be having more discussions, because of course you cannot talk about 700 and some pages in 75 minutes. Okay. We are going to make that public so that you are able to bring your questions, you're able to bring your concerns, and we won't be able to brush through it. Again, this was just a synopsis, okay? So if you want to be in contact with me, this is how you can reach me. Anywhere on social media, you can look for Legalese Please. I'm on YouTube, Twitter, Instagram, LinkedIn, and Facebook. The website, which is up and running, is www.legaleseplease.com. If you wish to email me, you can email me at legaleseplease.com. Make sure that you are able to connect as best you can. If you want to, if you want to join me in the Zoom room, I did post it in the chat. You can make sure that you can join me if that's what you wish. Just give me about 2 minutes in order to stretch my legs because I have been sitting for a minute. But I do want you to know what is happening. Okay. The last thing that I want to show you, which I promised you I would show you this information from my good friend Jennifer Lynn, who is an attorney. She is going to close us out, so to speak. I'm going to show you what she has put on her page so that if you need a succinct understanding of what is happening, here it is. I hope it is. I hope you can see it. Okay. Here it is. Let me find. Now I got to go back to where I was. Where was I? Okay. So, in her words, public service announcement. Illinois is eliminating cash bail to take a step toward making the justice system more fair so that a person who can't pay his $100 bond on a retail theft that is not sitting in jail awaiting trial while a rich armed robber can get out because they can pay the $100,000 bond. Now we can go into specifics and details of, okay, well, what about this example? I can't believe someone is sitting in custody 100. It happens. Okay. Don't get stuck in the details for this. I want you to get the overall picture. They're not opening the doors to the jail. The misleading memes and headlines make it sound like a person charged with the crimes on the list cannot be detained pre-trial. That is fake news. Each case will go to bond court before a judge, and they will look at, among other factors, the severity of the offense, the risk of not appearing in court, and the potential threat to the community if a person is released pre-trial. The judge will decide if the person is in jail pre-trial or not. It means that if they are not detained pre-trial, there is no cash bail attached to their pre-trial release. So you can't pay your way out of jail pre-trial. And I hate to break it to you, but right now there are people charged with violent crimes who are out of jail because they were able to pay their bond. So in short, this is about making sure that those who cannot pay their bond are not punished by having them serve time of incarceration ahead of time when they are presumed innocent without evidence or anything to substantiate their incarceration. Okay, so with that, I'm done. It was a lot. Take your moment to consider what has been presented. And then if you want to share it with others, do so. But also recall your energy that you are using to debate people who have no intention of having their minds changed or their information expanded. Okay, we're not here to convince everybody, but we're just here to present information, and then from there we go forward. So If you want to join me in the Zoom room, again, I have put the information in the chat of me being over there. Just give me a couple of minutes. And so once you go to this Zoom room, you will then be able to register. After you register, you will receive a confirmation email that will then allow you to come in. Okay, so let me know in the chat. How was it? Thank you, Brooklyn. Sora, it's okay. It'll be up here. You can review it at your leisure. You can watch it live and you can watch it later. I'm glad that you were able to talk about it, Jen, because we do need to know. And one of the things that we need to know is that we should not have to be in a time of chaos to be educated about the law. We should not have to be a witness, a defendant, a victim, a member of the legal professional community in order to know about the law. Ignorance of the law is no excuse. That's more than just a saying. That's the truth. Okay? All right. So thank you so much. I'm going to end this broadcast. I'm going to head over to Zoom. Please click like and share as you are moved to do so. And if you wish to get in touch with me, you can email me at legaleseplease@gmail.com. You can subscribe to the YouTube channel where you can watch this episode as well as other episodes that have gone forth. You can connect with me. I don't say followers. I say connections. You can connect with me on Facebook, on Instagram, YouTube, and Twitter. You can go to the legaleseplease.com website for more information. And with that, I want you to have a phenomenal day. Oh, before I forget, if you want to see this face again, I'm going to be on Court TV on Thursday, September 15th at 8 a.m. Central Standard Time. Okay, so I will be commenting on different rules, laws, cases. So if you want to see me again for free, that is where I will be. Okay, thank you so much for the ways in which you financially support, in which you support with your presence and your sharing. I am forever grateful. All right, I'm leaving for real. Have a phenomenal day. Take care. Bye-bye.